This is an attempt to recap some issues about 1331 SMJ that came up in office hours, so I'm thinking that there might be a little bit of confusion. So here goes. There's two main topics that I'm going to focus on. The first is the basic 1331 SMJ rule, and the second is how you apply this to DJ actions. Now, there are sub-issues for each one in terms of things that I think are confusing that I'll address. So for the basic SMJ 1331 rule, you have to understand the difference between federal claim and issue. And then for DJ actions, it might help to understand what a DJ is, why you would seek one, and then we'll talk about how that impacts SMJ analysis. Okay, so let's get going with the basic test. So, the 1331 SMJ, what you see on the left should be familiar. It's the basic provision, very short, that says district courts, i.e. federal trial courts, have the power to hear all the stuff that's in purple. So as we talked about in class, although this lists three categories, claims arising under the Constitution, treaties, and laws of the United States, that actually all collapses into federal claims. So federal courts have the right to hear cases that arise under federal laws. Now, what does this mean? Well, it is interpreted under the so-called well-pleaded complaint rule that we read. That's about the railroad case and the Motleys, to mean that you only have 1331 SMJ if you are suing to recover on a federal claim. Having an anticipated federal defense is not enough, because a defense is simply an issue and not a cause of action giving you a right to relief. So if you're confused about issues versus cause of action, definitely stay tuned, and we're about to talk about it. So, what exactly is a federal claim that would give you a right to 1331 SMJ? Basically, a federal claim is what we've been writing above the arrow on the board. So, in these situations, there's three here. Each one of these is a claim, but not all of them are federal claims. So, a battery, as you probably know from torts, is a state claim. So, in that first scenario, there would be no 1331 SMJ. Maybe there's 1332 if you satisfy amount in controversy and complete diversity. Now, looking at the second one, federal copyright against the defendant, what you're seeing is that says it's a federal copyright, and because it's on the arrow, this is a claim. So the second scenario is a situation where you do have 1331 SMJ. Now, what about the third situation, plaintiff suing for libel against a defendant? Well, you may not have gotten to this yet in torts, but libel is a tort claim. And as you know, all tort claims are state. So there is no 1331 SMJ. Same situation as battery. So basically, anything on the line is a federal claim. Now, what if you don't see a helpful arrow because you're just reading a case? How do you figure out if you have an issue or a cause of action? So let's run through a couple of examples. What if you have a First Amendment defense to a libel claim? Well, basically, a defense is an issue. It's not a claim. So that would not give you 1331 SMJ. Basically, a claim often has elements. So, as I said in class, for example, a negligence claim has several elements: duty, breach, cause of action. Each element is a sub-issue. In other words, each element is not a cause of action. That's just an issue. It would not be a claim. So a claim is something that gives you a right to relief, but you could have sub-elements of that which would be issues. So issues are smaller than claims. Now, what about if a party violated a federal law? Is this an issue or a claim? Well, it depends. Sometimes for a state claim, you can help prove a state claim with one issue that shows that you violated a federal law. In other situations, violating a federal law might give you a cause of action. For example, if you violate federal copyright laws or federal patent laws, there is a cause of action. So basically for 1331, you all are looking for a federal cause of action or federal claim. And in case you're wondering, claims and cause of action are the same thing. There's a federal law that gives you a right to relief. If that's the case, you have 1331 SMJ. Okay, so now that we've got the basics down, let's move to DJ cases, which are a little more confusing. First question is, what is a declaratory judgment? Basically, a declaratory judgment is the court saying, i.e. declaring, the rights between two parties. In general, the person who seeks a declaratory judgment has no actual claim. They could not seek money damages or an injunction, but they want the court to declare something, such as that they would not be liable for a patent claim because the patent is invalid. So somebody who thinks they might be sued for a patent claim might instead take the first step in suing to get the patent declared invalid. So that brings us to the second point. Why would you seek a declaratory judgment? It's basically somebody who thinks they're going to be sued. They want to take the first step in filing a case, because when you do that, you get to choose where it is heard, and that might be helpful. So let's look at an example. Suppose Microsoft is suing Apple, but Microsoft actually does not have a claim. But maybe Microsoft thinks that Apple might sue it because Apple has a patent that Microsoft is worried that Apple will say that Microsoft is violating. So Microsoft might seek a declaratory judgment that Apple's patent is either invalid or that it's valid but Microsoft still doesn't infringe. So what you should see in this case is that Microsoft could not seek money damages because it does not own the patent. Apple owns the patent, and Apple is the one who would be able to sue Microsoft, but Microsoft is trying to take the first step in seeking a declaratory judgment to say, well, if Apple sued me, it would lose. So what you should be seeing is that declaratory judgments actually don't come up that often. It would not typically come up in a tort case, but it is common in some cases like patent infringement, and also your book talks about maybe insurance cases. Maybe the insurance company would seek a declaratory judgment that somebody was outside the scope of their policies. So now that you understand what a declaratory judgment is, let's look at how this relates to SMJ. So the first question is, if there is a federal declaratory judgment act that provides you the right to seek a declaratory judgment, does that mean you have federal SMJ? So if you look at the left, that's the language that gives 1331 SMJ, and the right is a language providing that federal courts can hear declaratory, not just hear, but give declaratory judgments. So what words would give you SMJ? You should see them in the left, but not on the right. In other words, the words that you should see are in red. District courts shall have original jurisdiction. This is in 1331 and also in 1332. This is the so-called magic language that tells us courts have federal subject matter jurisdiction. That's what original jurisdiction means. If you look on the right, you don't see those red terms. Instead, you see different things. So there's no federal SMJ, but on the right, you see that any court of the United States, in other words, a federal court, such as a federal district court, may do the things in green. They clear rights and legal relations of interested parties seeking the declaration. In other words, the federal court may declare that certain parties have certain rights vis-a-vis each other. Now, the part in purple explains that the court has the right to declare interest even if the person who's seeking declaratory judgment has no right to relief. For example, in the Microsoft case, Microsoft is not entitled to money damages because it doesn't have a claim. The person who has a claim is actually the declaratory judgment defendant. Now let's look at an example in terms of how we evaluate 1331 for DJ claims. So, first scenario, Microsoft sues for declaratory judgment. In this case, basically what you're looking at is, would either party, plaintiff or defendant, have a federal claim under 1331? So even though Microsoft doesn't have a claim, if Apple would have a claim under 1331, then there is 1331 SMJ for this DJ claim. In other words, usually for 1331 SMJ, we're looking at the party asserting the claim, but because a DJ action is not an actual claim, then you have to look at who would have the claim. And in this case, it's Apple that would have a federal patent claim, so there would be 1331 for this scenario. Okay? Let's look at a different case. Now, what if Apple sought a declaratory judgment that Microsoft violates Apple's patent? This is basically the same thing, but with the parties flipped. So it's the same issue in terms of SMJ. There is 1331 SMJ because a party, Apple, would have a federal patent claim. Now, you may be wondering why Apple would sue for declaratory judgment, because declaratory judgment just declares the rights. It doesn't actually entitle anyone to money damages. So basically, Apple would never do this. Realistically, they would file a patent claim seeking the money damages. So this should reinforce that declaratory judgments are usually filed by someone who would typically be a defendant. Otherwise, you would just file what's called a coercive claims. Your book talks about coercive claims and coercive tests, but you don't have to know that term. That's just a fancy way for saying who has a federal claim. The person who has a federal claim, even if it's a defendant, would entitle you to 1331 SMJ. So all of the above situations, you have 1331 SMJ. So, just to recap, the basic test for 1331 is if there is a federal cause of action. So you look just at the federal cause of action. If a plaintiff is suing for a federal claim, there is 1331. If the plaintiff is suing for declaratory judgment, then that is not a claim, and you have to look at the possible claim that could have been asserted, even if it could have been asserted by the defendant. So if the defendant has a federal claim, as in the situations we talked about in the last slide, then you have 1331 SMJ. Hopefully that helps cement your understanding of 1331 SMJ.